Today's next conversation is with Lorie Smith, owner of 303 Creative, and her attorney, Kellie Fedorek, senior counsel at Alliance Defending Freedom. They're fresh off their 6-3 victory before the Supreme Court last week, in which the justices held that Lorie Smith cannot be compelled by Colorado's anti-discrimination law to create wedding websites for same-sex couples. Thank you very much for your time. Appreciate it.
Thank you for having us.
So it has been just shy of a week since the Supreme Court ruled in your favor. And my question is, have you had the opportunity to exercise your right under that ruling to say no to a same-sex couple that is coming to you for a wedding website?
Kyle, I have to step in and say that the comment is not even accurate. The court affirmed last week that the government cannot force anyone to say something they don't agree. I serve everyone. I have clients from all walks of life. I have clients who identify as LGBT. And what the court stepped in to protect is everyone's right to choose which messages they create for. As an artist, I simply want to create for messages that I agree with. So this ruling protects not only me, but the LGBT website designer, the Democrat speechwriter, the pro-life photographer, the Jewish calligraphy artist. Everyone should be free to create consistent with what they believe.
So I take that to mean that you have not had anybody come in for a service that you have felt that you couldn't ethically perform.
I have had many requests for same-sex wedding websites. I am looking forward to creating consistent with what I believe, and I've wanted that for 7 long years now, while the state of Colorado has coerced and compelled my speech. So I'm certainly looking forward to this next chapter and being able to create consistently with my beliefs, and I want that for each and every person.
I want to make sure that we're just clear on one thing. You're talking about the state coercing and compelling your speech. Were you coerced or compelled to create any speech that you didn't agree with, or was this simply a preemptive challenge that you didn't want to be in the future?
For the last 7 years, I have remained silenced and censored by my home state of Colorado and forced to create messages that go against the core of who I am. The state said if you create messages celebrating your belief on marriage between a man and a woman, that I would have to set those beliefs aside to create and celebrate speech, pure speech that the court agrees to, celebrating a view of marriage that I don't agree with. This is compelled speech, and I remained censored and silenced until the Supreme Court weighed in, and they did exactly that. This is not just a victory for me. This is a victory for each and every American. Nobody should be forced to create speech that goes against what they believe.
I just want to make sure that we're absolutely clear on this. You again just said I've been forced to create messages. Have you actually been forced to create any messages, or have you just felt like you couldn't enter the realm of creating wedding websites for fear of punishment from the state?
Kyle, I think it would be helpful if you actually read, Kyle, the Supreme Court's decision in her case that made it very clear, as did the 10th Circuit, even when they ruled against her, they said that she was under threat of the Colorado's law. Colorado has demonstrated a pattern and a practice of censoring speech. They've done that to Jack Phillips. They did it to Lorie Smith. And thankfully, the United States Supreme Court last week upheld that the government cannot force anyone, whether you're identify as LGBT, whether you're a Democrat, whether you're Lorie Smith, the government can't force you to say something you don't believe. And that should be something celebrated by all of us.
And with respect, Kellie, what I'm asking you about is your client's own words here about 30 to 60 seconds ago when she said that she was forced to create these messages. And I just want to make sure that we're all working from the same set of facts. So, Lorie, were you ever forced to create any messages, or was the impact that you felt like you were silenced because you couldn't enter this realm of work without fear of punishment?
Yeah, the state said if you create consistent with your beliefs, you have to set aside those beliefs to create a message you don't agree with. That is censored speech. So for the last 7 years, I have been standing to correct Colorado's injustice because the government should not force anyone to say something they don't agree. You may not agree with me on the topic of marriage. We very well may disagree, but the court's decision last week protects each and every person. Nobody wants to be forced to say something to create speech that they don't agree with. And disagreement does not mean discrimination. Free speech is worthy of protecting. I simply want to create speech that's consistent with what I believe. I want that for the LGBT website designer. I want that for people who don't have the same views on marriage that I do. Everyone should be free to speak consistent with their convictions.
Kellie, let's discuss the scope and the potential impact of this decision. The case obviously centered around whether someone providing expressive services could deny service to LGBTQ couples. Could somebody providing expressive services also deny service to an interracial couple under this decision?
Well, let me be very clear. Lorie serves everyone, and she also has clients who identify as LGBT. Moreover, the Supreme Court was very, very clear in its decision that non-discrimination principles remain firmly in place. So no one, regardless of who they are, can be denied services or goods and services under this decision. Simultaneously, the court also affirmed that no one can be forced to say something that they don't believe by the government. So this is a win-win for everyone, and something that all should be celebrating, and not trying to misconstrue this as something that's going to be harmful to anyone, because the court was very clear that non-discrimination laws and the First Amendment can coexist.
But again, the question is, could somebody under this ruling who is creating something, who is using their own personal expression and beliefs, their own creativity, could they cite this ruling to deny services to an interracial couple if that conforms with their beliefs?
Well, this case is about speech, and what you're saying there, some people may have very despicable views when it comes to speech, but the court said that people should have the right to speak freely, even on topics that they find offensive. But the most important point here is that nobody, regardless of how you identify, regardless of whether you're of your race or your religion, no one should be denied goods and services. So that's good news for all of us.
So again, so that sounds like, yes, in fact, under this ruling, somebody making an expression of belief, a creative service, could in fact deny service to an interracial couple if that's what they believe. I assume the same would hold for age, gender, nationality.
No one will be denied services under this ruling. The court was very clear.
So what would happen then if a same-sex couple came to your client and asked for a wedding website? They would not be denied services?
When the court was very clear that when speech is at stake, speech must be protected. And the court said that in our country, tolerance, not coercion, is our nation's answer. And that is the most important principle here. Lorie can and will and has continued to serve her clients who identify as LGBT. For her, she never looks at the identity of the person. When she's examining a request, it's always looking at what is the message that she's being asked to create, to promote. And I would think all of us, regardless of whether you're identifying as LGBT, whether you're a pro-abortion speechwriter, whether you're a Democrat photographer, no one wants to be told by the government what they have to create and what they have to promote or say.
Let's talk about how this might work in practice. Should businesses that intend to refuse expressive services to certain groups signal that to the public somehow? Should they put a sign in their window or a note on their website? Or do folks in these potentially impacted groups just have to inquire to find out whether they're eligible for the services?
You know, there have been suggestions like you are making right now about this case and about the implications of this ruling, and it's disheartening and honestly despicable. As I've mentioned multiple times now, the court explicitly and repeatedly said that non-discrimination laws will continue to be enforced. No one will be denied access to goods and services, and no one will be forced by the government to say something they don't believe.
Lorie, let me ask you, do clients coming to you asking for a wedding website, do you intend to give them any kind of heads up that if they're a same-sex couple that you don't intend to serve them, or is that something they just have to find out when they call or write in?
Well, I want to create consistent with my beliefs on various topics, and I simply want to choose messages that are consistent with my faith and my beliefs. And so it's important to me that every request that I receive, I carefully consider what those messages are that I'm being asked. And no one should be forced to create a message they don't agree with.
So it sounds like somebody would have to come to you, say, this is the message that I'm looking for, and then they would find out whether you would serve them, as opposed to kind of like a preemptive notice or something like that. Is that fair to say?
I'm always looking at the messages. Every request that I receive, I'm constantly looking at the message and messages I'm being asked to celebrate through my speech. And I'm never looking at the individual requesting the message. I have clients who identify as LGBT. It's always about the message, never about the individuals. There are some messages I won't create no matter who requests them.
So your case, Lorie, pretty closely mirrors the Masterpiece Cake Shop case with Jack Phillips. A lot of Coloradans know that case that also went to the Supreme Court. I want to ask you this. Jack Phillips's critics brought claims against him a number of times, including after he went to the Supreme Court. Do you anticipate that that is what life is going to be like for you going forward?
I don't know. I really don't know. I simply 7 years ago started this journey because I want to create consistent with what I believe. I want that for everyone. I know that if I want freedom for myself, then I must protect it for others. And the court has stepped in to protect our First Amendment speech for myself, for everyone. And since day one, I've just wanted to create consistent with what I believe. And I want that for everyone. I don't want the government punishing me or anyone else for creating something that is consistent with what they believe. Free speech is for everyone.
Kellie, you and your organization, Alliance Defending Freedom, also worked on behalf of Jack Phillips. Do you interpret this decision to also apply to his work, making custom wedding cakes? I know he got out of the wedding cake business so that he would not have to serve same-sex couples. Can Jack start making cakes again?
Well, we're certainly hopeful that the court's decision will help in Jack's case because Colorado and activists have also been harassing him now for over a decade. But more importantly, disagreement is not discrimination, and the government should not be able to label people's speech as discrimination in order to censor it. So we're hopeful that Jack and many others across this country will be able to exercise the fundamental right to speak freely that belongs to each and every one of us, regardless of whether you agree with Jack and Lorie or whether you do not.
One last question for both of you. A lot has been made of the fact that the same-sex couple that you said in your filings requested a wedding website from you does not appear to be real. The man whose name is listed is actually a graphic designer himself. He's a straight guy. He's been married for years. He says that this was not his claim. Now, we should be clear. You did not need an actual request to bring this case as a pre-enforcement challenge, but you obviously cited it as one reason why the ruling was needed. So I want to get you both on the record about this. Lorie, first to you, did you or somebody that you're associated with fake that request?
Absolutely not. There have been some egregious falsehoods and lies being spread about my case, and this is absolutely one of them. This was a request that I received the day after I filed. The truth is, I have received hundreds, if not thousands, of requests. Unfortunately, I don't do background checks on every request I receive. My assumption is that perhaps someone was trolling my website. Colorado made it clear that if I responded to this inquiry, along with all the other inquiries, that I could be punished. And so I just think it goes to show that there's a lot of misinformation out there. This is certainly one of them. I want your viewers and your listeners to hear that that is a false and absolute lie.
And given that it was the first such request that you got, were you curious enough to Google it? Because apparently it didn't take much thread pulling to figure out that it was fake.
Well, I have a lot of information that came in with the request, and I don't know if it's true or false. I assume that the person wanted a website. Their request was specific, and I assume that they wanted a same-sex wedding website. And I know that the state said if I had responded to that inquiry or the many others that I could be punished. So I certainly don't do background checks or investigate IP addresses for every request that has come in. I don't think any business owner does that. So it certainly is a legitimate request that came in. And I think it's really sad to see that there are so many false news stories about this in the media. At the end of the day, it doesn't even matter. There are hundreds of requests that have come in, and I simply cannot investigate each and every one.
And want to be clear on this from our end, that the request for a website was not a prerequisite to your pre-enforcement challenge, nor is it any grounds to overturn the Supreme Court's decision. But lastly to you, Kellie, just want to get you on the record on this. Did you or somebody else associated with Alliance Defending Freedom fake this request?
No, we absolutely did not. It made no sense for us to do so because, as you pointed out correctly, this request didn't matter to Lorie's case. This is simply a desperate attempt by opponents of free speech to try to delegitimize a decision that benefits all Americans and to go after Lorie, who has been censored for 7 years. Neither the 10th Circuit nor the U.S. Supreme Court once mentioned or relied on this request. And so it's truly an attack to undermine a very important decision that will benefit countless Americans for decades and to come.
Kellie Fedorek from Alliance Defending Freedom, Lorie Smith from 303 Creative. Thank you both for your time today. I appreciate it.
Thank you.
Thank you.